Well, I want to understand something. I think maybe some education will help me. I've always wondered why in Parliament there's the tendency to say, "Can you assure us?" What is that supposed to do?
When you give assurances to Parliament that something will be done, and that thing isn't done, or you fail to do what you have assured Parliament to do, that will constitute an offense in Parliament. And so we have got the assurances committee, which will take you on that assurance.
And that happens?
That sometimes happens, yes.
Sometimes.
At the last count, Nigeria was the chairman of that committee, and some ministers of state were hauled before the committee to answer questions on why they had failed in delivering on the assurance they had given to Parliament.
So if the Electoral Commission chairperson comes to Parliament and tells you that they have no intention of compiling a new register, all of a sudden they are compiling a new register, what will Parliament do?
No, will be contempt of Parliament.
Contempt of Parliament.
Mm.
So essentially, what can Parliament do to her?
Yeah, there are many things in the Parliament. The sanctions for contempt of Parliament are listed in the standing order. Now, if you deliberately mislead Parliament through an assurance, it will be contemptuous of Parliament. And mind you, Parliament is not just that building. Parliament consists of the representatives of the people. By extension, you will lie into the people of Ghana. And so that will be a serious offense.
Does that even include, let's say, in this case, I think one person comes to mind. John Kuma stood on the floor of Parliament, member of Parliament, Deputy Minister of Finance, and assured that there was not going to be a haircut of any form. Or that is not taken as contempt if the haircut then happens.
So, first of all, if in the view of the Assurances Committee, the John Kuma's assertion in Parliament constituted an assurance to Parliament, and there is a default on that assurance, the committee will have to take action. So it is for the committee to evaluate what John Kuma said and make a determination as to what it constitutes. Was he just contributing? Was it a statement or an assurance? Is John Kuma capable of giving an assurance? Was it a mere fact? And so the committee will have to make a determination.
In this case of the EC boss, where she has virtually in front of members of Parliament discredited her own register, and is saying that, give me a new CI, I have found a much more credible identity system I want to rely on, and then goes to say, we do not intend to compile a new register. You give her the CI, she goes back, because she's already discredited her own register. She goes back, comes, and decides to compile a new register. It means that it lies with the assurance committee to assess what she said and determine whether it is an assurance that can be taken on before any step can be taken.
The EC chairperson has the authority to give an assurance to Parliament, and that is markedly different from John Kuma. And when I give the example of whether John Kuma has the capacity to give an assurance or whether or not, you are looking at whether that is, he is responsible for that policy, and he authoritatively speak on that policy. Okay? If John Kuma says, well, there will be haircut, and a superior officer directs that there be haircut, can you hold him responsible? That's different from that's markedly different from the electoral commissioner, who is the authority, who has the authority, who speaks in her capacity as the commissioner. Now, I did not get the impression that she was discrediting the register. I got the impression that she said she had found a new way. Whether the new way is sufficient to capture or effectuate Article 42 of the Constitution, and all through the discussion, the Article 42 was not brought to bear. The import of Article 42 is to ensure that all Ghanaians who meet the requirement in Article 42, that is to say, are 18 years old and are of sound mind, are entitled, that is the word that the Constitution uses, are entitled to be registered and to partake or take part in public elections or vote in public elections. And so, can you use administrative procedure to frustrate the enjoyment of that right that is conferred on all Ghanaians of 18 years old and sound mind? That is the question. Now, you have the National Identification Authority that is registering people onto the National Identification Authority platform and designating them as Ghanaians or non-Ghanaians. Now, you have an electoral commission which says that I'm going to rely solely on the card issued by the NIA for the purposes of effectuating Article 42. All the discussion in Parliament centered around how to give effect to Article 42 of the Constitution. That was the discussion. Now, so how do you determine a Ghanaian? The Electoral Commission is of the view that the Ghana card is one such method. But is it exclusive? Are all persons who are Ghanaians and who are 18 years and above and who are of sound mind captured by the NIA? The answer we all know is no. It's in the negative. So why do you exclude those who are not captured? Why do you glorify your ignorance in assuming that those who are privileged to have been captured by the NIA are sufficient to determine who leads the country, and treat those who will not be captured by the NIA with contempt? Why will an electoral commissioner be interested in such an outcome? Because when you look at the history of TIs in Ghana, attempts have been made by the Electoral Commission through the various TIs to provide opportunity, different platforms for people to enjoy that right under Article 42. Bearing in mind that all the platforms do not adequately or sufficiently or totally capture all Ghanaians. And so you provide opportunities for people who have other means of verifying their Ghanaianness, their age of, date of birth, and the soundness of their mind to be able to get onto the register. That is what public officials in election management teams are supposed to do, to provide a broad range of opportunities. I don't know why we are so fixated on the fact that without the NIA card, we are going to be unable to provide a credible register. I don't know. Are we at our wit's end? It appears to me that is the lazy man's approach to compiling a register. Yes, compiling a register is hard work, but it means that you must employ all mechanisms at your disposal to ensure the enjoyment of that right under Article 42. And I'm disappointed that the electoral commissioner, who is a lawyer by training and who was in her previous life a civil society activist, who championed the right of people to be registered and to partake in public elections, now acting contrary to her beliefs. I'm very surprised and disappointed. Because you see, Senna, Blambazadu is a default region. So Namo is in the northeast region. So Namo is so cut off, so remote, that you cannot come to the conclusion that those in that area have been registered onto the national ID card. Are they entitled to partake in national elections or public elections? Yes. Have all of them been captured? No. Are those captured sufficient to determine the leadership of the country for those who have not been captured? No. So, all that we are saying is that yes, if the platform has adequate evidence to support the claim that all persons in Ghana who are 18 years old and who are of sound mind and who are Ghanaians have access to the Ghana card, then no one will be making an argument. No one. I mean, it will go without saying that yes, we have now reached a point where we can use the Ghana card. But until then, we should not conduct the election management activities in such a way as to exclude others who are otherwise entitled to determine the leadership of the country.
And you suspect that is what is being done in this particular regard? Because I realized yesterday, I listened to the National Identification Authority. I wasn't impressed. I wasn't convinced that they were in the position to provide the kind of support, assistance, or the cards that the Electoral Commission needed, because they were doing 15 years and above. Yet their numbers are lower than the Electoral Commission, who did for a few days, and they were doing 18 years and above. For those who were interested, not every Ghanaian, they still had more numbers. But the Electoral Commission still insists that this is the way to go.
That is the absurdity of the situation. The NIA is registering people for the Ghana card, not because the Ghana card is to be used for the purposes of establishing the citizenship of a person. I mean, there is no correlation between what the NIA is doing and what the Electoral Commission is set up to do. Now, but you can integrate the systems if they work to a level where they can be apart. And we all know that because they have different mandates and they are working at different speeds, and there are different obstacles and challenges confronting these two organizations, we have not reached that stage yet. I mean, the Kenatefa was very charitable. I mean, he has been put in place to register Ghanaians and non-Ghanaians and issue them with cards. He's doing that. I mean, at his own pace, amidst the challenges. He should not be rushed. He cannot be rushed into issuing cards for everybody. Today we are being told that some cars have been locked up because of non-payment of the service providers' claims. So why do we rely on the NIA, or why is the Electoral Commission bent on relying on the exclusively? I mean, you can rely on the NIA. I registered with the Ghana card. But exclusively, why is it saying that it wants to exclusively rely on the NIA? I mean, is that something that the Electoral Commission knows that we don't know? Why is the Electoral Commission bent on frustrating the enjoyment of Article 42, the right under Article 42? Is there something that is there that we don't know? That is what is beating the imagination of most Ghanaians. Because you see, Sana, the Electoral Commission, when you take that, I was trying to explain to you, when you take the CI, they should have come to the conclusion that all CIs, all the CIs, until they came into office and started using, and even the NIA itself is caught in that offense, started excluding certain documents, including the birth certificate. The NIA excluded the voter ID card, and the NIA excluded the voter ID card. So this is an organization that, when it came to Parliament for an amendment of its laws, thought that your card, the voter ID card, then was a worthless document, document, and could not be used for the purposes of primary verification of who a Ghanaian was. Could not be used as a source document. Today, the electoral commission is saying that, for us, we think that your document is almost foolproof, and so we are going to use your document. And I'm saying that if everybody had that document, we won't be arguing, but not everybody has it, and we don't know when they will have it. And it will be an offense of egregious proportion to exclude even a single person who wants to vote from voting.
That's your narration of essentially what transpired when the NIA rejected the voters' ID card, and what the EC is doing, not then back my claim that she is virtually discrediting even her own register.
Well, why I think that I don't want to go along that trajectory is that I think that question was asked by Honorable Haruna when he said that about 10 million, the voter register is about 13 million, 13 and above, 10 million registered with the NIA card, 3 million registered with other documents, especially the guarantor system, and was taken to imply that 3 million were in quotes on the register illegally or inappropriately. And the electoral commissioner answered that no, at the time that the registration was taking place, the legal regime that regulated and guided the electoral commission in the registration of potential voters allowed for the use of the guarantor system. So all those people who are on the voters register by the guarantor system in accordance with the legal system that prevailed at the time the register was being compiled are there legally, constitutional. That was the answer. I don't know whether I got
it. And the history, and I think what your former leader, Honorable Haruna, was trying to perhaps see, and what he was trying to suggest is a suspicion among a lot of the members of your party that what the EC is seeking to do is to repeat what was done in the case of the NHIS, those who use the NHIS to register. Because they even presented a card. A court decided that they were illegally on the register. And that same court then decided that they should be expunged, only for the court to say, now let's create an opportunity for them to register with some other card. And there are those who are, yeah.
The court did not say that they were illegally on the register. What the court said was that, and I think it's the Abu Rahman case.
Yes.
What the court said was that the National Health Insurance card was not a card that was issued for the purposes of determining the Ghanaianness of the card holder. And if you look at Article 42 of the Constitution, it says Ghanaian. So basically, primarily, that card, a card that will entitle a person to be on the register, must be a card issued to establish the Ghanaianness of a person. And insofar as the National Health Insurance card was a card that entitled you to a service and did not call into question your identity as a Ghanaian, your nationality as a Ghanaian. All those who had registered using the National Health Insurance card should be given an opportunity to register again using a card that establishes their nationality. That's what the court said. The court did not say they were there illegally.
Thank you. And Alhaji, if we put the vouching system to the test that the court used, would it survive?
It will survive.
Why?
Because my village, until recently, not everybody went to school. In fact, because of superstitious beliefs, the people in my village said that it was even an abomination for somebody to know your date of birth. So taking a birth certificate was a no-no, because that will disclose your date of birth. And so they were growing up, a lot of people, including myself, who was born in a hospital, who didn't know his date of birth. But my father is a Ghanaian, a Dogomba man from Vitim. My mother, a Ghanaian, a Dogomba woman from Yohane. Their mothers and fathers are also Dogombas who conferred the citizenship on them. So if you roll back, you come to understand that because of the lack of education or documentation within the Ghanaian culture, the vouching system or the guarantor system is being used for the purposes of establishing who Sana Israeli is or who Inusah Fuseini is. So you can trace my father, you can trace me to my father, who can be traced to his father, whose father can be traced to his father's father. And so we know him as Sana. He's the son of Numbo. And so you got a son. So that is the guarantor system. That is just all about the guarantor system. So when we're doing the national identification system law, when Governor Dumo's father was the head of that, and we met somewhere around Kaswa, we said that, so if the guarantor system is actually to work very well, then the head of family or the assemblyman or the chief or an opinion leader in the community ought to be the guarantor, because they would have known or capable of knowing who that person is. And so they come to vouch for a person who hasn't got any of the documentary proofs to establish his Ghanaianness. And that was what we put into the law. Because we realized that we were not going to be able to capture all Ghanaians based on the baptismal certificate, the birth certificate, the passport, or any other document, because there simply was a large number of Ghanaians who were not documented, undocumented Ghanaians.
Then I guess you must be, what do you call it, shocked that the Electoral Commission is throwing away that same system.
It's a shock. And that's why even though the NIA threw away the voter ID card, then when it came to Parliament to amend the law, it did not throw away the guarantor system. He always sought to make it robust. He always sought to make it, to make sure that they cut down the likelihood of people abusing the system. So there could be a punishment, perjury. So if you go to swear an affidavit and come to, then it turns out that it's not true, then you could go to jail. So that's what they sought to do. But they knew that, yes, to be able to capture all Ghanaians, not all Ghanaians are on any form of documentation. But they are Ghanaians. In fact, it is not a document that confers citizenship on you. If you look at the Citizenship Act, it is not defined in the court in terms of documents. is defined in terms of relation. Who was your father, or who was your mother, or who was your grandfather? That's how a person, a Ghanaian, is defined, not in terms of a document. It is not said that a Ghanaian is a person who holds the national identification card or the Ghana card. It's not defined that way.
But are you? Do you also have that suspicion slightly that this may get to the point where we all may have to queue and vote and register again?
Yeah, because the Electoral Commission has conducted itself in such a way that they've lost a significant trust. There's a trust deficit in the Electoral Commission. And this is because of their very act. One such act is the compilation of a new register. When they said that the register was overfloated, it was argued that the register was not overfloated. They said they were going to do it. They did it. And the numbers they got on the register was more than the total voter population on the whole register. So it means that there was no scientific basis for the compilation of a new register. And they did not even tell us that in the compilation of the new register, how many foreigners they detected. So you see, so one will call into question, why the compilation in the first place? What did we achieve by the new compilation? Two, so this is one of the trust deficits. Two, the other commission conducted elections, came to declare results of an election, changed the election of the declaration almost 9 times, including declarations that were not signed, that could not be attributed to anybody by the commission. That's another matter of trust deficit. Now, three, the Electoral Commission itself, the new recomposition of the Electoral Commission now, was largely as a result of a coup d'etat organized or perpetrated against the whole Electoral Commission on the sole basis. And I'm saying this because I was privileged to be on a program with one of the leading members of the NPP who said that Charlotte Osei was an NDC member. And so it was the distrust they had for her, which made them cook up a ghost petitioners and got her out of the Electoral Commission and appointed somebody who was their own. So the fact of appointing Jean Mensah, who in her previous life as a student was an NPP activist, and who is almost playing the game, including the deputy commissioner who was a patron of the MPP on campus, on the University of Ghana campus, also erodes the trust and deepens the suspicion of the Electoral Commission. This is why the Electoral Commission is being viewed with a lot of suspicion by my party and by discerning Ghanaians. Anywhere you go, people ask you, is the Electoral Commission really going to do what they are doing? Why are they doing what they are doing? And the line such question is a question of trust and suspicion. Yes, every Electoral Commission carries some trust deficit. But when an Electoral Commission conducts itself in a way as to deepen the suspicion, then it loses the trust of the people.
Alhaji, let me then conclude by seeking some education from you. Yesterday, the Speaker sat as chairman of the Committee of the Whole. He said he will be personally responsible for the compilation of a report. What happens next?
So there's the Committee of the Whole. Parliament works in committee, and so when Parliament is not, yesterday I was even surprised that this Committee of the Whole was held in public. Committee of the Whole normally are not held in public. They are held without the public participation. So we're all listening to what was going on in Parliament. Now, so I believe that why they did that was, one, they recognized that the Chief Executive Officer of the National Identification Authority and the Electoral Commission have no capacity to appear before the plenary and address the plenary. That is Parliament sitting at Parliament. So, but the finance minister has, I mean, the president, the vice president, ministers of state, and deputy ministers can appear before the plenary. So the only way to accommodate them was to move Parliament from the plenary into a committee, and a committee of the whole. And this time, make the proceedings of the committee of the whole public. Now, because it's a committee, all committees are chaired by a chairman, and the standing orders provides for that. So the Speaker of Parliament becomes the chairman. So, like all committees, a report will be presented to the House, and the House again will debate the report. So that's what is going to happen.
And based on what at what point in time would then be a decision to allow the EC to lay the bill or not, the EC or not?
Well, I think that when the debate is hard and the vote is taken, and all debates must end, that's a consensus. All the debates must end in a vote. It can be a voice vote or a decision. I mean, so it will be a vote. So when the debate is hard and it's either voted to accept, Parliament votes to accept the report, and which report includes a recommendation that the bill be laid and it's adopted, the bill will then be laid. The CI will then be laid. The constitutional instrument will then be laid, and then it will start its journey to maturation.